Good morning, everyone, and welcome to another edition of our Justice and Pieces guest speaker series. Today, we're joined by an old colleague of mine from law school many moons ago. I guess not so many moons, but Shaneka, it's so nice to see you, and thanks so much for doing this. And maybe you can start. You can tell us a little bit about your journey from Osgood all the way to where you are today.
Yes, thanks for having me, JP. It's been a while. So we were at Osgood together from 2017, no, 2007. Yeah, so it's been a minute. I guess I'll take a step back. My name is Shaneka Shaw Taylor. I'm the founder and principal lawyer at Taylor Litigation Professional Corporation. So I am a proud Jamaican. I was born there, grew up there, and I moved to Canada right after high school. So I did my undergrad degree at Windsor and then law school in at Osgood 2007 to 2010. And then from Osgood, I summered and articled at a big Bay Street firm. When that was done, I was called to the bar. I ended up at a mid-sized litigation boutique downtown Toronto. And I was there for 11 years. Same firm for 11 years, partner for 5 of those 11 years. And my practice was primarily municipal defense work, as well as real estate litigation and commercial litigation. And so I branched out on my own, to start my own firm, Taylor Litigation, in 2023, so 9 months ago. And it's been a ride ever since. We focus on commercial litigation, real property litigation, and commercial. So I've kind of put the municipal stuff behind me, and it's been an interesting transition. Um, I have experience being a partner in the full firm of running a business and what that involves and being involved in the decision making of a practice. And that's certainly helped me with transitioning to my own litigation boutique. But there's still, things that um, I wasn't necessarily prepared for coming into this. And I'd say the biggest piece that I wasn't necessarily prepared for, I knew I'd have to do it, but it's different when you know something and when you're actually put into the situation. It's how much time I would have to devote to the business of law and running a practice. I'd perhaps say it takes up half, if not a bit more, of my time. But it's been great so far.
Perfect. So we'll get into the practice and sort of that transition in a second, but I do want to know more about kind of the litigation and certainly the real estate litigation aspect there to it. I know, I've seen some articles and stuff that you're involved there in real estate side as well. So what are the kinds of litigation matters when you say commercial litigation that for students who have no idea that you would be handling, and then specifically in the real estate realm?
Yeah, so commercial real estate is really you're helping clients who are businesses resolve their disputes, right? So that could be disputes with shareholders, partners, contractors, suppliers, anything revolving around the business and how the business operates. And a part of that could be property related. And then property litigation is similar type of work, but in addition to helping businesses resolve their disputes, you can be helping individuals. So we do a lot of work for buyers and sellers that are involved in real estate transactions, whether those transactions didn't close for a variety of reasons, or they did close and there was an issue that arises after closing. We also represent or assist real estate agents in collecting commission claims, generally claims that are not covered through their insurance that's provided to them as a realtor. And then we also work for private lenders who are faced with a default situation and they need to enforce a loan agreement with a borrower. Sometimes we act for borrowers as well. So that could be a secured loan, i.e. a mortgage, or an unsecured loan through like a promissory note or something of that nature. So we do the full gamut. We also tend to do some work relating to zoning disputes with municipalities or right-of-way issues with municipalities. So Yeah, it's a pretty broad practice area with respect to real estate litigation. I'm also a licensed realtor, and I sit on the Disciplines and Appeals Committee for RICO, which is the regulatory body that governs real estate agents. I just love real estate. So the only thing that I don't do real estate related is transactional closings. So I'm not a solicitor that does closings, but I help on the dispute side if there's an issue that arises.
Perfect. So let's maybe walk through. I know sometimes, obviously, these matters, especially in civil litigation, may take a number of years to go from kind of where that dispute is to the end. So maybe you can kind of break down like a step by step, and it could let's do real estate, I guess, because we've just been talking about it, and you said you love it. So no, especially today, and the last year or so, that you're seeing a lot of situations now because of the interest rates, partly, but. Um, where maybe they thought they had the funds, or and then things changed, or for whatever reason, and then there's a dispute, or I mean, you could give another scenario maybe that you've worked on where there's an issue affecting the transaction, or as you said, even after the transaction things are discovered. So kind of what happens in the immediate aftermath, where someone contacts you, um, and if it does go on and lead to potentially litigation that goes all the way to a trial, and how often does it go all the way to trial as well? I think a lot of times in advocacy class where we're learning about trial advocacy, and then we realize that we may never really use it as much as we thought.
Yeah. So advocacy to me includes a lot of things, right? It's not only you going to court and making submissions and representations to a judge, you're still advocating for your client when you're drafting documents. You're advocating for your client when you're doing settlement negotiations. So all of that to me is an advocacy. But from a fact scenario, if we take a typical a simple real estate transaction that doesn't close. So let's say buyer and seller enter into an agreement of purchase and sale for a property. It's a firm agreement, and which means that there is no condition on the buyer doing anything or the seller doing anything. And as we've seen in the market recently, interest rates have really affected the valuation of properties. Lenders are being a lot more conservative in how they lend and how much they lend, and the loan to value that they're lending to. So, what we're seeing a lot of these days is buyers being unable to close because they're not able to get the financing that they thought they would get to close. And that's usually a factor of um, they can't qualify to the same degree that they would before because of the stress test, or they have qualified, but the bank isn't giving them as much mortgage monies as they thought they would have got. So then they're left with having to come up with the difference between what they're getting in a mortgage and the purchase price. And most times, people are just not able to find that extra cash, right? So what happens is, in that scenario, the buyer will default in a transaction, and the seller will either relist the property. In most cases, they'll relist the property for sale. And because prices have gone down, they are accepting new offers at a lower price. And then they're coming back to the original buyer to get them to compensate them for that difference. And so typically speaking, what would happen is when they will come to me, either the buyer or the seller, the first thing that we would do is try to see, okay, well, what is your exposure here? If you're the buyer, and if you're the seller, what are you looking at trying to accomplish? What is the dollar figure that you're trying to recover? And depending on, we do the math, and depending on what that number is, I always tell my clients, try to see if you can negotiate a settlement, right? And that could mean either side giving and taking on what their expectations are. It's one thing to say, if you're on the buyer side, that okay, they owe me 200,000, 300,000, and that's what I'm going to get on a judgment if I go to court. That's all fine and good, but you also have to factor in what are the circumstances that led this buyer to not close. Obviously, if they had the money and if they could, they would have. So are you likely to get 200, $300,000 out of them, even if you do get a judgment in court? right? Is that a realistic possibility? Do they have assets that you can go after if you get your judgment? So all those things are considerations that we walk the clients through before they even consider starting a lawsuit, right? Because going into lawsuits, it's not a cheap thing. Lawsuits are expensive, right? The first step in commencing a claim is the pleading stage. So that's where each side exchanges the statement of claim for the plaintiff, and the defense for the defendant. And if there's a reply on behalf of the plaintiff. And then the next stage is the discovery stage, and that's twofold. You have the documentary discovery, where each side exchanges documents between them, sworn affidavit of documents. And then the next stage is the examination for discovery phase, where each side gets to ask the other side questions under oath about the lawsuit. And that's really the first stage where you get to see what the evidence in the claim will be when you get to trial, and what evidence you need to marshal depending on which side you're at. And then depending on what jurisdiction you're in, if you're in Toronto, the next stage is mandatory mediation, because mediation is mandatory in Toronto. And that's where each side sits down with a neutral third party, a mediator, to try to see if they can resolve the issues between them. And if the case can settle at mediation, great. And if it can't, we move on to the next stage, which is a pretrial. And in the pretrial stage, that's where you meet with a judge of the court, and they try to do the same process as the mediation. So the judge will try to see if the case can be settled. And it's the difference between the pretrial and the judge and the mediation is that the judge will oftentimes give you their perspective on where they think the case will go if it does end up in trial. Where they see the risks or weaknesses on each side, and where they see the strength in each side's position. And usually, I'd say most cases settle either at mediation or the pretrial stage. Because again, to get to those stages, we're talking about tens of thousands of dollars in legal fees that you're expending. Civil cases, rarely get to trial, particularly in real estate litigation, very rarely get to trial, because it's just, depending on the issue, there is a well-developed case law on most issues in real estate litigation that you can point to that says, okay, depending on which side you're on, this is more than likely what's going to happen, right? So there's a well-developed case law. So there really isn't a need to get to trial because it can be resolved before then. So I'd say 80 to 90% of cases, if not more, settle before they get to trial. And as I said, getting to trial is a very expensive process. And not only expensive, it takes years to get to trial in our current judicial system, where the courts are so backlogged. You're looking at 5, 6, 7, if not more years before you get to trial. However, because we have such a well-developed body of case law in the real estate litigation bar, and most cases tend to be the run-of-the-mill, this person did close for that reason or the other, there is a process by which you can get to judgment or adjudication of the issues faster, and that's through the summary judgment process under Rule 21. And summary judgment is a motion that you can bring you can bring it at any stage in the lawsuit before you set it down for trial. And that's where you are asking the court to make a determination on the issues in the lawsuit at an earlier stage. And usually the courts have found that, the run-of-the-mill real estate transaction that doesn't close is a good type of claim to adjudicate on a summary basis. So instead of, 5, 6, 7 years before it gets resolved at trial, if the parties can't resolve, you're perhaps looking at months to a year and a half, to get it before a judge through a summary process. So that's pretty much the high-level overview of the steps involved in a typical run-of-the-mill breach of contract real estate case.
Perfect. So thanks so much for that overview. I think very helpful for people who are interested, or even those who may be listening that may be going or have a dispute and want to kind of look at, well, what's ahead, because again, it's not like on TV, right, where you see like, everything's resolved in an episode, right? That if you do continue all the way through, I mean, as you mentioned, the cost, but the time, right? And if it's a dispute, and as we looked at, 200 to $300,000, well, could you wait 7 years to maybe get, and as you also rightfully pointed out, what if they don't have any assets, right? I mean, if they did, they probably would have tried to sell something to close if need be, right? If this was maybe like a first time home buyer.
Yeah.
Um, anything else in terms of, in those situations? Um, I mean, maybe even before closing ends, right? Because does it make sense to like extend the timeline? I mean, I guess 2 years ago it wasn't an issue because you'd be like, well, the sellers actually probably were happy because they would end up selling for higher
Yep.
after that period of time, and it's not. I mean, I don't know exactly today. I mean, I guess we're getting into to mid spring into summer, so maybe it's changing a little bit, but. Does that negate anything on the, if you are on the buyer side in situations where they're going to sell it for just as much, if not more? Is there really a loss on the seller side? Is that like an argument that comes up, or?
It's certainly an argument that comes up, but as I said, the case law is fairly well developed in the area that, and the case law is essentially that even if a seller sells for more than what you agreed to pay as a buyer, at the very least, the seller is still entitled to keep your deposit for compensation for lost time, just to compensate them. So that's the best scenario to be in as a buyer, that the seller sells for more, but you're still walking away with at least your deposit being forfeited. The worst situation is where the seller has to sell for less. And that's often the case in this current market where houses aren't moving as quickly as they were and prices aren't as high as they were 2, 3 years ago. So we're seeing more and more that sellers aren't able to get the same price that they did before. Some are lucky too, but most times they're not.
And is there anything? I mean, and I also like your point about advocacy doesn't start at trial, right? Because if you're effective, at the very beginning in the the ADR sort of stages there of negotiation, or the mandatory mediation, or even I suppose mediation before you even go to litigation, you could potentially look at. Um, you can resolve these matters efficiently and effectively, and avoiding spending more and more money.
Absolutely.
Anything you've learned, from dealing with all these kinds of matters, about, any tips about sort of the pre-trial advocacy that's important for practitioners to know, or students to know, and in other areas of law where the same principle can apply, of how to advocate right from the get-go to get it sort of tossed away.
I would say the biggest thing that I've learned, and I'm still, flexing that muscle, is creativity. You really have to flex that creative muscle when you're trying to craft settlements and negotiations that benefit both sides, right? A lot of times, I think we are drawn to settlements that, okay, this is what I'm entitled to. Um, this is what I'm going to be prepared to knock off that amount. So if I'm entitled to 200,000, okay, I'll give you a break for 50,000. You give me $150,000, and that's the end of the story. Most people don't have $150,000 sitting around, right? So how else can you craft that settlement where both sides are happy? Maybe it's breaking down that settlement over a period of time, or maybe that's giving the seller something else that is also valuable to them based on their scenario. Maybe it's okay, maybe I can give you 50,000 today and perhaps convert the other 100,000 into some type of secured mortgage. Or maybe I have a service that would be beneficial to you that we can convert the remaining settlement into a quid pro quo exchange of service. So it's really being creative and trying to craft a solution that's just one that works for both sides. Recognizing that the reason why a buyer has gotten themselves in this situation is because they're not liquid right now with the full amount of money that's owing to a seller. So creativity, I think, is the number one key.
And I guess another piece of advocacy that also doesn't maybe get the glory as much as the courtroom is written advocacy. I think you had recently had a post about getting to the point, right? I mean, and sometimes being concise there is a lot easier to digest than,
Yeah,
especially when dealing with counsel, where sometimes it's just a bunch of extra fluff in there that kind of takes away from your point. So maybe you could tell us some tips, written advocacy or legal writing, that you found very helpful in all your years of practice.
definitely. So I'll never forget this, and I have a terrible memory. I'll never forget this. Law school first year, Professor Haig, I think it was constitutional law, and he said this, when you're reading decisions, start from the end. Look at what the court decided, the ratio of the case. Read that first, and then go back to the beginning and read the case with that perspective in mind. Because you want to figure out how did the court get to the decision that they were at. Um, Written advocacy isn't writing a Shakespearean novel. It isn't even writing a romance novel, right? You have to be point forward in your advocacy. Get to the point and get to the point quickly. You have to consider your readers. Your reader is a judge who's overworked, has a lot of cases on their docket, and need to understand your client's claim as easily, as succinctly, and as clearly as possible. So paint the picture for the judge as to why it is that your client is in the right and should be successful. So get to the point and get to the point quickly. I think, as lawyers and as legal professionals, we are trained before getting to law school, when you're writing essays in undergrad or college of, give me a 2,000 word essay, and you're really struggling to get to that page limit. So, you're putting in all these adjectives and adverbs and, trying to fill up the page as much as possible. But when you're doing written advocacy in law, it's almost the opposite, right? You're trying to use not necessarily as few words as possible, but you're really trying to just get to the point and get to the point quickly and in a way that is still painting a picture for your reader so that they understand what you're trying to accomplish. Right? Long gone are the days where we're using long, flowery prose to describe here and after, and there before to describe what we're trying to get across. You really have to be succinct in what you're saying, to get your point across. I know that perhaps judges would disagree with me when they say that they don't make up their minds before hearing oral submissions. But I think majority of judges, okay, I think judges tend to have a picture of how the case is going to be decided simply based on your written advocacy, your factum that goes before them before they see you in a courtroom. And if you're able to convince a judge or get them on your side before you get to them in the courtroom, that I think is the best form of advocacy. Because when they get to the courtroom, they're really just asking you questions to clarify what you've put before them in the written document. They're not there for you to tell them from the beginning what happened. That's not the point. The point is for them to clarify anything that they didn't understand, or if they did understand, want to confirm for themselves when they're writing their judgment. So that written document that you submit to the court before you even get to the court, I think, is perhaps more important than the oral submissions that you make when you get to the court.
Yeah, because I mean, you're obviously coming from the starting position, right? So if they're coming into court already knowing enough of what you've done, you've done the legwork. Before we kind
Exactly.
of transition over to maybe talking about sort of the building your own practice, so I wonder if you have any other tips, whether it's writing or other advocacy, or in or maybe even specifically in commercial litigation, real estate litigation, that you could share for anyone that may be starting out. Because I know one of the things we're going to get into is mentorship, and sometimes when people start their own practice, they don't have the benefit like you do in your case of all this years of working at firms. sometimes it comes out of necessity, and it's hard for sole practitioners to find those nuggets. So anything you can share, on the litigation front that you think would be very helpful.
I think the one thing that I can think of off the bat is, you know, we're as human beings, we tend to take on our clients' issues, right? We tend to internalize the files that are in front of us. And I see that time and time again with opposing counsel that I'm dealing with, that they take things and their clients' positions personally. And you have to think of, as a professional, this profession, you're in it for the long run. And there's no way you can internalize every single case that comes before you, right? So you really have to take a distance between the clients that you're representing, the files before you, and your personal views on things and issues. And you also have to consider that you are not fighting your opponent. Your clients maybe have issues between them, but you personally shouldn't have an issue with opposing counsel and treating them in an unethical or disrespectful manner, right? Because this is one file in the lifespan of your career. And chances are you're going to be dealing with that opposing counsel on other files in other instances, right? So maintain cordial, collegial relationships as best as possible. That's going to help your mental health. It's going to help you resolve the file better when everyone is just respectful, calm, cool, and collected as much as possible. Yes, there are going to be times where, he or she or they say something that, pushes you off the deep end. And your natural instinct is to, respond by email as quickly as possible and give them a piece of your mind. But I say, take a step back. Even if you draft an email, don't send it, right? Take a few days or hours, however long, cool down, and then respond, right? I think that piece of advice will take you a long way.
Perfect. So let's kind of talk about your practice now. You said it's been 9 months. You've grown your team already. So what was it like, making that leap, going out on your own, compared to being at a firm where you're a partner at, and what have you learned thus far in the first year?
Oh, geez. It was a scary decision to make. It took me many months to make the decision and to actually action the decision because I was at a great firm. Like I'm still close with the people that I worked with before. Um, they're wonderful people. I really had a great time at that firm. So to make the decision, and I made it for me and where I wanted to take my practice and the type of firm that I wanted and the type of way that I wanted to practice. So at our firm right now, we are all digital, and I try to um, integrate as much technology as much as I possibly can, um, to streamline things to make the client experience a bit better than my previous firm. So just my vision for what practice should look like, how quickly we get back to clients, how quickly we deliver on our deliverables, just all those things. I felt like I needed to be on my own to do it the way that I wanted to do. So really, that was the genesis of me deciding to go out on my own. But it was a scary prospect, and you know, I I'm the type of person where I have to have certain things in line before I make a decision or I action something. So I spent many weeks and months putting things in place to launch the firm and do the things that how I wanted it to come together. And so far, it's been great. We've been busy and hopefully that continues. And a friend of mine was saying, man, you really started the firm at a good time when the market's going down and people are in disputes. And it just happened to work out that way. So we're really busy. And as you said, we're growing the team. We have, I think we're up to six people in the team right now. So it's been going really well. But at the end of the day, I take a lot of what I've learned from working in partnership at my other firm and brought it into here, how to manage people, how to make decisions, how to allocate resources, all those things I had to learn, and I'm still learning as I go. But the point I guess I want to make is it's tempting to, when you're just starting out, if you're meeting up with opposition as to get in a position somewhere to branch out on your own, put up your own shingles. And personally, this is just a personal opinion. I don't necessarily think I agree with that approach. I certainly wouldn't have done it because when you're starting out, there's so much to learn about the practice of law and how to effectively serve clients and just learning the law, that learning the business of law on top of that, that's a lot, right? So to the extent that you can get experience somewhere at an established firm or established shop before branching out of your on your own, I highly recommend that because that gives you the cushion to make mistakes, learn the law, learn how to practice before you go out on your own. There's a reason why, um, you know, the Law Society um, have audits of people, sole practitioners in their first year of practice, and there's a reason why people who have started out with their own firm tend to get in trouble more with the regulatory body, in the early years because it's just a lot to learn, right? So to the extent that you can get that experience, mentorship, and guidance at a shop before you hang out your own shingles, I highly recommend that. And to the point of mentorship, I think it's super important. Even as a an established lawyer right now and going into my 13th year of practice, I still need a mentor, right? Because I don't know everything. There are still things that I need to learn about running a business, about certain claims that I perhaps never have dealt with before. So I think it's really important to find someone who is where you want to land, where you want to be, and having a few people, not just one, a few people who have the fruit on a tree that can teach you as you go along, right? There's nothing worse than being in a silo on your own trying to figure it out. That's just a recipe to go mad.
Yeah, I mean, I'd be amiss to, from the law society perspective, right? They have the coach and advisory network that if you don't have personal connects, right, that you can go to, and they can offer support. And I do understand, I believe that as of January 1st, they have a new program for first-time sole practitioners that you have to complete, which I think I don't know the specific details. I'm sure it'll come out soon. But again, to your point, that a lot of the mistakes are made by sole practitioners because it's a lot, right? I mean, it's different than when you're an associate, you come in and here's the work you need to do, and you go and do it. And if you don't know, previously you can go down the hall and ask somebody. But even today, you can jump on a Zoom call with one of the senior partners or somebody to help give you that guidance, and you're not worried about any of the non-law stuff, as you point out, right? I mean, so maybe some of that, right? I mean, what have you found, outside of the actual practice that you didn't realize would take so much of your time, and any advice, whether it's on marketing or networking or building your firm, that you can share with anyone who may be on, where you were about a year ago, getting ready to make the decision to go forward.
Yeah, I think the two biggest pivots that I've had to make is on those two fronts. So the networking, brand development, and getting out there and building the business, of business development, and on the accounting piece. So, making sure I'm aware of and complying with the Law Society requirements for trust account and billing and docketing and all those things. I say those two things take up majority of my time, right? The business development and the accounting piece. So to the extent I understand, if you're just starting out, you may have to do that all on your own. And as you build and grow, I'd say invest in a good bookkeeper, an accountant to help you as you go along. And on the business development front, there's nothing that can replace getting out there, building connections, um, allowing people to see who you are, what you do, and how you can help them. I spend a lot of time right now doing that.
Yeah, I mean, and you don't realize, again, especially I think a lot of lawyers um, think it's like, oh, it's just like another little piece there, but I know you could be highly successful, right? Like, you have a number of awards and everything, but if you're not getting the business, then especially, you're on your own, right? You have your own firm, then it really affects your bottom line.
Absolutely.
Any other, I guess, tips on that front, right? About recognizing maybe that you should get to pivot with your approaches of how to sort of manage everything, and then you have other lawyers that are looking to you for guidance on top of that. So, anything that you've learned, and I know you have someone fairly new. I don't even know if they've even started yet, but of being able to sort of be that mentorship piece for others while still needing sometimes, some mentorship on your own, as you point out.
Yeah. I think it's important to recognize two things that you're not going to be for everyone, right? Your tribe is going to be your tribe. The people who are for you, they're going to gravitate towards you and they're going to want to work with you and be your people. And that's okay. They're not going to be for everyone, right? I always think that it takes a lot of different people to make this world go around. So you're not going to be for everyone, and that's fine. But you also have to recognize who you are. And so, in the process of launching the firm, I worked with a great leadership coach who helped me to understand and confirm, my attributes and my traits. So whether that's doing these assessments, like the Gallup test, to figure out what your strengths are, who are the type of people that you work well with, and what are your shortcomings, so that you can work on those. So, when we are onboarding new people on our team, I've bought into that. Like I do the strength testing to see, okay, what is this person's attributes? What are they good at? How did they work? How did they communicate? And we have that dialogue about, okay, this is how I am, and this is how you are. How can we best mend those synergies so that we work well together? And I think same thing works for any relationship that you're building. It's really important to understand how well to communicate with that other person. Uh, Same thing with if you're finding mentors. Yes, it's great to find people who you admire, the people, I think we tend to gravitate to the people who have the outward success, the awards, and so forth, and be like, I want you to be my mentor. But you also have to take a step back, look at that person, and say, okay, do they work well with what I'm trying to accomplish and who I am as a person, and will that relationship work? And you also have to think that in a mentor relationship, as in any relationship, it's a give and take. Can't just be taken and not giving. So find ways to pour into your mentor as much as they pour into you. Find ways to give back to your community as much as your community gives to you.
Yeah, I mean that's one of the things, right? It people don't realize there's got to be a mutual something as well, right? Because if you're always like, hey, do you have send me a file? Like at some point, why you and not anyone else that they can offer that guidance to or support to? Um, and no, even if that means like, every once in a while sending something the other way, right? Or just having a chat about something. Anything, I guess, in terms of learning now, I mean, getting into 9 months in, right? That you just said you're all digital, right? So how is that different, and how do you make that all work? Um, Given, I mean, I guess the landscape is different than in the days where you had to be up on the nice brick and mortar location. But what are the challenges with going digital? Um, and do you miss sort of the in-person, um, or how do you kind of replicate that in-person experience
Yeah.
digitally?
So when I say we're all digital, so all of our files, everything that um, we work on is stored digitally. So we don't have filing cabinets where you have physical files. We don't have none of that. Everything is digital. Um, a lot of our meetings tend to be virtual. A lot of the court appearances that we have tend to be virtual because a lot of courts are still doing virtual appearances. So we really had to invest in the right technology And not every piece of technology is going to have everything that you want. So it's really figuring out what you want and how to integrate different technologies together. So we really took a big investment on the technologies that we use. A lot of integrations. Zapier is my best friend because it allows you to have different programs speak to each other, sync to each other, so that you can work as seamlessly as possible. But there's nothing that, from a client relations perspective, that there's nothing that beats in person, right? So to the extent that, clients want to meet with us in person, or we're trying to land prospective clients, we generally opt for in-person meetings. Just that face-to-face physical touch is preferred. So technology is great for some things. It's great for automations. It's great for to helping you, on the back end of the practice. But some things just can't be replaced with technology. Even with going to court, it's super convenient post COVID, where we can go to court virtually. But sometimes, or even examinations for discovery, but sometimes things are lost when you're not in a physical courthouse and or not in a reporter's office questioning a witness under oath in person, right? There's certain things that on credibility, for example, that you can pick up in person a lot better than you could virtually.
Yeah, I mean, I think that's sort of where we're battling with, right? Is terms of what how to, you go from one end because we were forced to go to the other end during the pandemic, and now it's like, well, where exactly on this pendulum swing? Because certain things like, I know hear from a lot of criminal lawyers that they feel cross-examination is best done in the courtroom because who knows what that person is it has in their home or wherever they are. And, if you don't get to kind of be there and have that sort of feel, it's a lot different. And then others will say the opposite. They say, well, because I can actually see you in this little box right in your eye, that I feel that I'm talking to you. And I prefer the virtual sort of things there. So it's interesting. And as you point out, and beyond that, of course, with files, I don't know if that, in terms of your fully paperless, I think one of your classmates, Palat, talked to me about, I think he was paperless years ago or something, about how that works and the importance of technologies because clouds have been hacked and this and that, and the law study obviously has rules
Yeah.
with maintaining that. But what have you found in terms of switching and doing that in terms of keeping all of that organized and compliant? Anything to share with anyone else that might be thinking of going that route?
Yeah. Well, before I answer that question, when we were talking about, questioning witnesses under oath, it just brings to mind this funny story. I remember watching I think it was a TikTok in the States. I guess they can do this. They can record court appearances. In Canada, we can't. In Ontario, we certainly can't do that. But I remember watching this one TikTok where it was a criminal proceeding and the Crown um, was questioning the complainant. And before she even started, she said, Your Honor, I have a concern. I have a concern because I believe that the accused is in the home of the complainant as we speak. And it was something to do with like a domestic violence charge. And so she starts with asking the complainant about, where you are, who's in the room with you. And you can kind of see like she kept doing one of these, like looking off camera. And she's like, oh, I'm here by myself, kind of thing. And the accused was on another screen, and the judge asking questions, where are you? And he gives the address. Is anybody else there with you? Nope, nobody's there with me. And somehow the um the prosecutor had sent police over to the complainant's address. And this is all unfolding live in the courtroom. They get to the address, knock on the door, and lo and behold, the accused was in the same room as the complainant, even though he just gave evidence under oath in the proceeding that, oh, he's at some other address far away, right? And so that's just an example of the drawback of, you know, being virtual and having these proceedings virtually, because I can't even tell you how many times I've been in examinations, and it's clear as day that somebody else is in the room helping the opponent answer questions when they're not supposed to, and they're swearing up and down that nobody else is in the room with them, right? So that's just one of the drawbacks of being in a virtual environment. But I digress. To answer your point on the technology, um, as I said, it's not perfect. There are programs that we use that I wish could do a better job. So, for example, not to knock any program, of course, but I'll just tell you the programs that we use. So we use Cosmolex, the Office 365 suite, um, Zapier, of course, and Dubsado. So a lot of these programs have great features, but I really wish there was like one practice management software that I can be my be all and end all. Unfortunately, we're not there yet, but that's something that we're working towards. And then there are other programs that I wish we could have, like NetDocs is an example that integrates really well with Cosmolex, but it's a bit pricey. But that's something that we're working towards. And some of these technologies are super um, good at encryption and two-factor authentication to make sure that your information is safe. Um, but I say all this to say is we're paperless. I started the firm with that goal in mind to not have a shred of paper in terms of client files. And coming from a firm where the pandemic really forced us to move online and to move things online, whereas before that, every file was physical and we had filing cabinets in the office, like, taking up all this real estate of physical files. And there is something to be said about having things physically because God forbid, you know, there's a hack or God forbid servers are down, or even though, these technologies say that they have all this security in place, things happen, right? So there's pros and cons to having physical files. There's pros and cons to having everything digital. It's really about, what your risk level is, what you're comfortable with, and how you can put in systems in place to help you back up things, mitigate things as best as possible.
Perfect. So Shanika, so thank you so much for taking the time and joining us here and sharing about commercial litigation, commercial real estate litigation, as well as starting your own practice, the digital, going paperless, and everything else we've discussed. Any final words of wisdom for any of the students or new licensees that may be listening about anything that you found helpful from all the way back in 2007, I suppose even before,
Mhm.
and to today that's helped build you to where you are, and congratulations again on all your success and awards and speaking engagement. I think it's funny. I just saw that you talked about buyer and seller remedies. I'm like, oh yeah, that's good that we touched on that because I know you did that thing a couple days ago too as well.
Yes. No, thank you. I think that an overarching piece of advice that I would give is just be yourself. There is room for all of us and all our personalities. You don't feel like you have to be someone else or have what others have to be successful. Success, define your own definition of success, whatever that looks like for you, and work towards that. Don't have the FOMO that I think we get trapped into from time to time. Just be yourself, be authentic. That comes across way more than try to be someone else. And yeah,
Perfect. So thanks again for taking the time, and thanks for everyone for tuning in. Take care.